Good evening, Dean. Good evening, classmates. I am Roger Albacete. I will be reporting Articles 2071 to 2075 of the Civil Code. Article 2071 provides, the guarantor, even before having paid, may proceed against the principal debtor. 1. When he is sued for payment. 2. In case of insolvency of the principal debtor. 3. When the debtor has bound himself to relieve him from any guarantee within a specified period, and this period has expired. 4. When the debt has become demandable by reason of the expiration of the period for payment. 5. After the lapse of 10 years, when the principal obligation has no fixed period for its maturity, unless it is be of such nature that it cannot be extinguished except within a period longer than 10 years. 6. If there are reasonable grounds to fear that the principal debtor intends to abscond. And 7. If the principal debtor is in imminent danger of becoming insolvent. In all these cases, the action of the guarantor is to obtain release from the guarantee or to demand a security that shall protect him from any proceedings by the creditor and from the danger of insolvency of the debtor. In all these cases, the action of the guarantor is to obtain release from the guarantee or to demand a security that shall protect him from any proceedings by the creditor and from the danger of insolvency of the debtor. Right of guarantor to proceed against debtor before payment. As a rule, the guarantor has no cause of action against the debtor until after the former has paid the obligation. Article 2071 enumerates 7 instances when the guarantor may proceed against the debtor even before payment, and specifies the remedy to which the guarantor is entitled. The purpose is to enable the guarantor to take measures for the protection of his interest in view of the probability that he would be called upon to pay the debt. The provisions of Article 2071 are applicable and available to the surety. The case Manila Surety and Fidelity Company Incorporated versus Bato Construction and Company, 101 Phil, 494-1957. Facts of the case. Bato Construction and Company, a partnership, the member of which are the other 3 defendants, requested it to post, as it did, a surety bond in favor of the government of the Philippines to secure the faithful performance of the construction of the Bacara Bridge. The defendants would indemnify the company for any damage, loss, cost, or expense of any kind, including attorney's fees, which the company may at any time sustain or incur as a consequence of having become surety upon the bond. It also appears that a complaint by the laborers in said project of Batu Construction and Company was filed against it and the Manila Surety and Fidelity Company Incorporated for unpaid wages. It was found that Batu were in imminent danger of becoming insolvent and are removing and disposing of their properties with intent to defraud their creditors, particularly the plaintiff company. Defendants Tunak claims that the signing by Carlos in Bakiran of the indemnity agreement for and in behalf of the partnership Bato Construction and Company did not bind the latter to the company. As the Bato is not bound, he, Andres Tunak, as a member thereof, is also not bound. In the event that partnership is bound by the indemnity agreement, he invokes his right to exhaustion of the property of the partnerships before the plaintiff may proceed against his property. Issue: whether or not the last paragraph of Article 2071 me by availed of by the surety. Ruling of the court. Yes, even if there should be a consideration or price paid to a guarantor for him to ensure the performance of an obligation by the principal debtor, the provision of Article 2071 would still be available to the guarantor. Article 2071 of the new Civil Code provides that the guarantor, even before having paid, may proceed against the principal debtor to obtain release from the guarantee or to demand a security that shall protect him from any proceedings by the creditor or from the danger of insolvency of the debtor. When he, the guarantor, is sued for payment, it does not provide the guarantor be sued by the creditor for the payment of the debt. It simply provides that the guarantor or surety be sued for the payment of an amount for which the surety bond was put up to secure the fulfillment of the obligation undertaken by the principal debtor. Remedy to which guarantor entitled. The guarantor cannot demand reimbursement for indemnity because he has not paid the obligation. His remedy is to obtain release from the guarantee or to demand a security that shall protect him from any proceedings. The danger of insolvency of the debtor. Remember that there are certain cases that the guarantor cannot claim the benefit of execution, and in such cases, it is but proper that the guarantor be given the right to proceed against the debtor. The guarantor's remedies are alternative. He has the right to choose the action to bring. Release from the guarantee. Power to release guarantor give only to creditor. Article 2071 provides the guarantor the remedy of filing an action to obtain release from the guarantee. The use of the term release from the guarantee is inaccurate, as the debtor does not have the power to release the guarantor from the guarantee. Since the guarantor is obliged to the creditor, only the creditor has the power to release the guarantor from the guarantee. Release by creditor cannot be compelled. In this regard, the creditor cannot be compelled against his will to release the guarantor, which a property right. The release of the guarantor's obligation to the creditor, it connotes, therefore, either a remission or a novation by subrogation, and either operation requires the creditor's assent for its validity. Release by debtor with consent of creditor. The debtor cannot release the guarantor from the guarantee through the debtor's own will. The debtor may be able to release the guarantor from the guarantee if the debtor pay the creditor or obtain the consent of the creditor. The release of the guarantor ultimately depends on the consent of the creditor. Distinction between Article 2066 and Article 2071. First, the first provides for the enforcement of the right of the guarantor against the debtor after he has paid the debt. The second, for his protection before he has paid, but after he's become liable. The one gives a right of action after payment, the other protective remedy before payment. Second, the one is substantive right, the other of the nature of a preliminary remedy. And third, the one gives a right of action, which without the provisions of the other might be worthless. The remedy given in Article 2071 seeks to obtain for the guarantor release from the guarantee or to demand a security that shall protect him from any proceedings by the creditor and from the danger of insolvency of the debtor. While Article 2066, strictly speaking, has no such purpose. When the guarantor's right under this article become available, he has passed the point where a preliminary protective remedy is of any value to him. Sought for payment. Under Article 2071, the guarantor may proceed against the debtor when he is sued for payment. According to Castan, contemplates a situation where the guarantor cannot claim the benefit of exclusion and wishes to protect himself against the possible insolvency of the debtor. Illustrative cases. Winsol and Strip versus Tan Sun Ko, 16 Phil 670, 1910. Facts of the case. C instituted an action against D for the recovery of an indebtedness. Before C could secure judgment, G brought an action against D for the payment of another obligation for which G acted as guarantor. D confessed judgment in favor of G. Immediately after obtaining judgment, G caused to be levied upon under execution all the property of D. C commenced an action to set aside the judgment, claiming it was obtained by the fraud and collusion, and that G had not paid the debt for which as guarantor he obtained the judgment. Issue. Is a guarantor who sues his principal before paying the debt himself entitled to recover judgment for the debt? Ruling of the court. No. It being evident that the purpose of Article 2071 is to give to the guarantor a remedy in anticipation of the payment of the debt, which debt being due, he could be called upon to pay at any time. The only procedure to enforce the right is by action. G availed himself of that right against D, the debtor. The method employed by him to realize his end was unusual but not of itself fraudulent. The evidence adduced was held insufficient to establish fraud and collusion as would justify a decision setting aside the judgment itself. But while G has the right to obtain as he did the judgment against the principal debtor, he ought not to be allowed to realize on said judgment to the point of actual collection of the same until he has satisfied or caused to be satisfied the obligation, the payment of which he assures. Otherwise, a great opportunity for collusion and improper practices between the guarantor and his principal would be offered, which might result to the injury and prejudice of the creditor who holds the claim against them. In short, a guarantor who obtains judgment against his principal cannot execute said judgment against the latter's property until he has paid the debt for which he stands as guarantor. For the second illustrative case, General Indemnity Company Incorporated versus Alvarez, 100 Phil 1059 1957. Facts of the case. G Indemnity Company filed a complaint against D for the recovery of 2,000 pesos representing the amount of a loan allegedly taken by D from PNB, the payment of which G guaranteed with an indemnity bond, and for which D, as counter-guarantee, executed in G's favor a mortgage on a parcel of land. There exists a controversy in the complaint and answer as to whether or not G had actually paid this obligation to the PNB. Issue. is the action of the guarantor or surety against the principal debtor for payment before the guarantor has paid the creditor premature. The court ruled in affirmative. The matter of whether or not the guarantor has actually paid the creditor should be decided in the affirmative before the guarantor can claim reimbursement from the principal debtor. Under the last paragraph of Article 2071, a guarantor who has not paid the creditor can proceed against the principal debtor only for the purpose of obtaining release from the guarantee or a security against an eventual insolvency of the debtor. An action by the guarantor against the principal debtor for payment before the former has paid the creditor is premature. Recovery by surety against indemnitor even before payment. 1. Indemnity agreement for benefit of surety. An indemnity agreement is not executed for the benefit of the creditor, but rather for the benefit of the surety. And if the indemnitor, principal debtor, voluntarily agrees to its terms and conditions, the obligations arising from the contract have the force of law. Second, indemnity agreement may be against actual loss as well as liability. An indemnity agreement whereby the indemnitor binds himself to indemnify the surety for any damage or prejudice the latter may sustain under the surety bond, may provide for indemnification not only against actual loss but against liability as well. Such agreement is enforceable and not violative of any public policy. In a contract of indemnity against loss, an indemnitor will not be liable until the person to be indemnified makes payment or sustain loss, while in contract of indemnity against liability, the indemnitor's liability arises as soon as the liability of the person to be indemnified has arisen without regard to whether or not he has suffered actual loss. Third, such agreement valid. A stipulation, therefore, in an indemnity agreement providing that indemnitor shall pay the surety as soon as the latter becomes liable to make payment to the creditor under the terms of the bond, regardless of whether the surety has made payment actually or not, is valid and enforceable, and in accordance therewith, the surety may demand from the indemnitor even before the creditor has paid. Hence, an action by the surety against the principal debtor and the indemnitor to enforce payment under such an agreement is not premature. And where the principal debtor are simultaneously the same persons who executed the indemnity agreement, the position occupied by them is that of a principal debtor and indemnitor at the same time, and their liability being joint and several with the surety, the creditor may proceed against either. The principle of guarantee in Article 2071 does not apply. That is, there is no more need for the surety to exhaust all the properties of the principal debtors before it may proceed against them. Article 2072 provides, if one, at the request of another, becomes a guarantor for the debt of a third person who is not present, the guarantor who satisfies the debt of may sue either the person so requesting or the debtor for reimbursement. Guarantor of a third person at request of another. The guarantor who guarantees the debt of an absentee at the request of another has a right to claim reimbursement after satisfying the debt either from the person who requested him to be a guarantor or to the debtor. Article 2073 provides, when there are two or more guarantors of the same debtor and for the same debt, the one among them who has paid may demand of each of the other the share which is proportionally owing from him. If any of the guarantors should be insolvent, his share shall be borne by the others, including the payer in this same proportion. The provision of this article shall not be applicable unless the payment has been made in virtue of a judicial demand or unless the principal debtor is insolvent. Right to contribution of guarantor who pays. 1. Restriction. Article 2073 contemplates a situation which arises when one guarantor has paid the debt to the creditor and is seeking reimbursement from each of his co-guarantors, the share which is proportionately owing him. It is required, however, that the payment must have been made in virtue of judicial demand or because the principal debtor is insolvent. Without a requirement, the guarantor who pays the debt under circumstances giving him the right to contribution may proceed directly against his co-guarantors for their respective shares, with the latter having to incur the trouble and expense of claiming afterwards from the debtor what they have paid. On the other hand, if the guarantor proceed first against the debtor, who, as a consequence, makes payment, we not only the debtor but the co-guarantor as well would be disregarded at once from their obligations. In the cases specified, the guarantor is perfectly justified in paying the debt because any delay on his part may increase the liability for interest, expenses, and other items. 2. Effect of insolvency of any guarantor. If any of the guarantors should be insolvent, his share shall be borne by the others, including the paying guarantor, in the same joint proportion. This follows the rule in solidary obligation. 3. Accrual and basis of right. The right of the guarantor who has paid the debt in either of these cases is specified to demand proportionate contribution or reimbursement from his co-guarantors is acquired ipso jure by the guarantor by virtue of said payment without the need of obtaining from the creditor any prior cession of rights to such guarantor. Example: G, H, and I are this guarantor of a debt of 9,000 in favor of C. If D becomes insolvent, the right of G, H, and I to proportionate division of their obligation ceases as far as C is concerned. Articles 2065, paragraph 2 and Article 2055, paragraph 3. C may demand payment of the entire obligation from any of the guarantors. If G pays the whole debt of 9,000, he can later demand from H and I 3,000 pesos each. But if H is insolvent, his share shall be borne by G and I proportionately. Under paragraph 2, G can therefore demand 4,500 from I. If the benefit of division ceases for reasons other than the insolvency of the principal debtor, the right to reimbursement granted to G against H and I may only be exercised if G makes payment in virtue of judicial demand by C. Article 2074 provides, in the case of the preceding article, the co-guarantors may set up against the one who paid the same defenses which would have pertained to the principal debtor against the creditor, and which are not purely personal to the debtor. Defenses available to co-guarantors. In the action filed by the paying guarantor against his guarantors for their proportionate shares in the obligation, the latter may avail themselves of all defenses which the debtor would have interposed against the creditor, but not those which cannot be transmitted for being purely personal to the debtor. In the preceding example, if G sues H and I, the latter may raise the defense of payment by D, by virtue of which the obligation was extinguished. Other defenses such as fraud, prescription, remission, illegality, etc. may also be set up because they are defenses inherent in the obligation, the effect of which is to nullify the obligation or render it effective. But if D was a minor at the time the obligation was contracted, the defense of minority is not available to H and I because it is personal to D. Article 2075 provides, a sub-guarantor, in case of the insolvency of the guarantor for whom he bound himself, is responsible to the co-guarantors in the same terms as the guarantor. Liability of sub-guarantor in case of insolvency of guarantor. In case of the insolvency of the guarantor for whom he bound himself, a sub-guarantor is liable to the co-guarantors in the same manner as the guarantor whom he guaranteed. Example, in the example given under Article 2073, if F is the guarantor of I and I become insolvent, F is liable to G for 3,000 pesos or 4,500 if it is also insolvent. Thank you, and once again, good evening.